featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history.
Okay, abusia mamu akwaba na mencheche nsembi nchireo. Moka se emre bi na yeto aba wieye on the 8th 9th mo baby. And I mebe bo secret audio bi chire mo se Chief Justice the NDC full soldiers afa na ho adwen mokai on say me catch mo say there's a plan B ampa yeto aba no wieye Mahama so in na ye nche ene yete se enkofu so mo de petition yakọ but me pese me refresh wa adwen kakra na utie de course.
If NDC get to taste of the parliamentarians, we use that power. They call it supreme power. So then we're going to use the supremacy to control the parliament, to control the legislative, and to control the judiciary by passing everything that you want through the parliament, and the parliament will overthrown Tokuno. They shouldn't dare, because what we are going to do to them now, they will run away from this country.
Right. Eti me be kasem we to abonten. Enu nansa. Fofie wantana se na wadware abamu. Ena wo mo hya se Muhammad bae no from 7 anche no mo search se wo mo de petition bi a eni nyina so. Edi ekoti ama. Enti me no kasa ne Chief Justice ene wo pie bonten so na in fact na awreho. Ensem bi okan ye fa na busuafo bi a wono mahwere ne wofa bi a friend Justice Akwa wo se dan kure kokun ni papa wo ne busuani ni wo mu no ye de ne wofa in fact tia ha se wo de tia maame na nkasa tia nanu asem tia ha se ne yento aso tia maame na nkasa.
Featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. Featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the director of human resource of Sh0cking. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed.
Na esim say mami omo hye ne ya na ensem obeka yi eyawrehosem pa na Chief Justice kasa wiye no enye anso ha o ene wo be chirechire mu say wo mo de sobuo bi abono charges ye de abono nyina eni nyina so ensem a NDC fo atwa to no so in fact wo chirechire ni nyina a wo hu ne say omo hyada say omo pese on resign by force be ya bra wa bre over 30 years no omo fa ni nyina eno o chirechire a o di awreho Chief Justice e di awreho eno so ni.
The clear danger is that through this flagrant violation of CI 47 and the darkness of the current proceedings being held in camera behind the walls of Edu Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be having from the president, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out in the light of day. The final and fourth reason for this statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long.
And so on so far. And now Sassi Subio, Chief Justice says Subio say, a yadia NDC for Bomutrim Pose, Omopeso Motete Nequa. Just say Omopese, Omana Suya Sh0cking. So now war catch the judges at 1 year say, a qua walk away, and you won't 1 year yunti and emum judges for yina, and ne any diano. A china say yanka, na yan swanoa. Echina wonso ebedros waka we dichere judges for nyina se emane nya wode na bia enne na ye wono justice Gertrude Tukono echina ebedru wonso so all kasa no di waka ni ti ha say.
Behind me is every judge in the country. Behind me is every commissioner or head of an independent constitutional body in the country. If this is successful, it will be tried on anyone. I am not countering these processes for myself, but on account of the leadership burden that I carry. If the nation is willing to accept these developments in its democratic journey, it must be understood that I sounded the warning and the nation took the decision to be passive about it. I cannot share the burden of those involved in designing and implementing this enterprise of pretending to use Article 146 proceedings to remove a Chief Justice through unknown and unlawful means by keeping quiet about the violations of law and due process. Neither can I make anyone's burden lighter by resigning or retiring, instead of proving that not even one of these wild claims in a collection of petitions is even remotely true or meets the standard required for removing a judge. Now, allow me to take a bit of your time to walk through these petitions. They have been in the public domain for some months now. They are actually available on the internet, so I'm not addressing anything that is not known in the public space. Many negative things have been said about me through public commentary on the petitions, although the petitions were responded to 7 days after I received them. And so anyone who cared to acknowledge my side of the story would have had no need to keep repeating the petitions without discussing them with the answers. And when I provided these answers, I also added with evidence to prove that each allegation was either a lie, a wrong opinion about how work is conducted in the judicial service, a wrong opinion on the work of judges or a wrong opinion on the duties of a Chief Justice.
Afei, yenhwe bibi te se judges ahodo aka. Ede bone na otu susu se maami eye Justice Tuko no wode aye judges aka. We ye Justice William Atuguba. Obi bebi sa se ono nso so owo etan bi di ma Chief Justice ya na fi se na bi osusu se kese wono odi Chief Justice na enuro no so ana. Enye ono nko a NDC General Mosquito Anita de Soso Nana ya Jantua all NDC aparachiches won mu nyina empe maami asem enokre se President Mahama epese osa maintaining another term iti or package judges agu Supreme Court ana eno ntina ode judges enso akoka ho ya na ano den maami ni chire nsem yentie Chief Justice Gertrude Tuko tie no.
Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. The second reason for making this statement is though I'm in the process alone, its effects ripple far beyond me as a person. This process will affect how all Superior Court justices and future Chief Justices may be removed from office. It also affects commissioners and heads of independent constitutional bodies set up to protect the freedom and justice of Ghanaian citizens as guaranteed under the 1992 Constitution.
Now, utie maami nsem okan nyina. Ntu susu se charges ya omode bo maami ensem onipa bi kokeka ye friend so-called petition enso gina mu de na susu se adwenepo bay na what the NDC administration wo mutrim all the political class ade ade wo hwa ade pa no mahunu wo ye sure sent BBS na we democracy ana eye autocracy still na no hunu say jomama pese wo yi maami free ho na wonya kwade ne judges kuguo na assemble won in fact what they say ni attorney general was want me in court attorney general in court bia o and the bia media mu and wo ye na we ye ken a Ghana Bar Association and o matu bi e de amane attorney general hwe no so
meetings are going to be held in public. We are going to have media briefings of what turns out, but you see, before the person responds to, you don't lay the charge of the person in public because the person is not going to be tried in public. Ultimately, when you come and give the press conference, you are going to go back into the courtroom and still bring your indictment, let the person, the charge will be read to the person, the language that's for the person to plead guilty or not guilty. So how do you go and put something in public that ultimately is going to end up in the courtroom? And then the sad thing is that at that time, the individuals involved have not been charged. So they also don't have the right to respond. Because if today the Attorney General comes out that I am going to charge Yao Boafo with this offense, I've not been charged. I don't even know the particulars. I cannot even instruct counsel. You get the point, to know what is going to happen. Because the Attorney General can give a rendition of events or facts in public, and then the bill of indictment may be something else. So for me, because proceedings are going to be held in public, it's not in camera, that every Ghanaian can go into the courtroom to observe what is happening. There is no need for us to have these press conferences.
The Chief Justice all but insinuated that there was some political agenda at play to oust her, and that this whole process is a result of sin. Let me place on record, without fear of contradiction, and let me be clear that no such political agenda exists. His Excellency the President took an oath to which he was incidentally sworn by her ladyship, the Chief Justice herself. And in that oath, he swore to abide by the 1992 Constitution. He is enjoined to act a particular way when he receives petitions of the sort that he has received. And that is all that His Excellency has done. He has had no choice in the matter. The president cannot say that he has a view about how things should be done, and therefore, if petitions have come, he will fail to act. If he did that, he himself would be in breach of the Constitution, and therefore, he has been enjoined to act as any responsible leader or president of the Republic of Ghana would be required to do, as stipulated by the 1992.
The final and fourth reason for this statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned, rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started.